Briggs. I'm the attorney for the district. The proceeding you have before you has no legal weight anymore. Last Friday, the Superior Court voided the resolution of the district that began this process and all associated actions. In other words, the application that was submitted by the district is as if it had never been submitted at all. You have zero legal authority to do what you're proposing to do today. A lawsuit's being filed this morning to have that conclusively determined as to LAFCO. If you proceed, I suspect we'll end up in court in the next couple of days on some sort of TRO or injunction. Even if it weren't void, conditions that you put before the voters have not been satisfied. You told the voters that the district had to negotiate another interim ambulance contract. That hasn't happened. And you gave that to the district. Your staff report today says that's something that you can wave your hands at and make go away as a matter of discretion. That's not what you told the voters. In addition, you told the voters that the district was going to dispose of the Cuyamaca fire station. That hasn't happened yet. You don't get to wave your hands and make that go away. The district has to do that. So I don't understand what the rush is. Furthermore, as you know from the letter from Ted Griswold, if the district is dissolved, the property actually reverts back to the Conservancy, and nobody else has any authority to enter the premises. You would be trespassing, you would be committing a takings, and because that's a unique circumstance, you are in effect leaving that community without lawful fire service. That triggers a secret review. I have copies of the judgment and the writ that were entered. I have an unsigned copy of the resolution that the board adopted last Saturday in response to the judge's writ rescinding it. I'm just representing to you that it was all rescinded. I just don't have the signed copy with me at the moment. You will need to decide what you want to do. I'm happy to talk about the council, but my recommendation is that you not be cowboys and move forward with this today while things are at best in legal limbo. And as I said earlier, because of the Brown Act violation that procured the application, there's no application whatsoever. That has been decided in a case called Hernandez versus Town of Apple Valley. It's from our very own 4th District Court of Appeal. In that case, the Court of Appeal invalidated election results when the election was procured through a Brown Act violation. So rather than exposing everybody to a bunch of legal liability, I would encourage you not to move forward today. Let's get the lawyers in the room. Let's get all of this sorted out. Do it professionally. Do it responsibly. Let's not leave everybody in limbo. Let's not be cowboys. Let's do it the way San Diegans deserve. If you would like copies of those documents, I have them here. Who do I give them to?
Would you please give a copy of those documents and you'll pass them on?
Sure. There's just one copy.
Okay.
Now, have you had a chance to review the documents that Mr. Briggs presented today?
Yes, just briefly. And at this point, I don't see any reason to delay. I don't believe those documents present a reason for LAFCO to delay. It's plain that they intend to file some action and then a court can resolve the dispute back and forth. But I don't see a reason as we sit here right now for LAFCO to delay based on those documents.
So if LAFCO were to go ahead with the recommendation of our executive director today, and then this goes to court and there's a temporary restraining order or whatever, what does that do then to the fire and emergency medical services in the Julian and Cuyamaca Fire District? Where are we on that? Chief?
So fire services would remain in place with the County Fire Authority and CAL FIRE. The Cuyamaca Station 51 is staffed today with 3 people, and we have a total of 6 personnel on at the Julian Station, 3 on the paramedic engine and 3 on the CAL FIRE engine, along with the battalion chief on duty. So essentially, the fire services that have been in place as part of and up to and leading to the dissolution are in place today, so there would be no disruption in services. The ambulance agreement changed last Friday from the Julian Fire Protection District to the county's contracted provider, Mercy Medical Transportation. They currently have a paramedic ambulance staffed on duty today in Julian, concurrent with the contract that they have with the county and the Emergency Medical Services Agency.
Would you care to respond to the allegations by a couple of the speakers?
The previous ones from 2017, we have responded to several times. The ones that were brought up from last night, I have no reason to believe, none of this is brought to my attention, to my staff, so I would have to go back and look. As you know, all of our vehicles have automatic vehicle locators. It is all tracked through satellite technology. The times are recorded. I would be glad to go back and look at any specific, whether it's today or any time, any allegation that our staff has not gotten lost, because we have very, very detailed records on those.
Thank you.
If we take this action today, are you confident, and I just want to get this for the record, are you confident that you can provide the fire and medical services that Julian, the community of Julian, the Julian Fire District needs, and you'll be able to keep the same level of service that's there today?
Unequivocally, yes.
Thank you.
Any other questions of Chief while he's up here? Okay,
Thank you.
thank you. I have a motion and a second.
I have a question for the commission on behalf of the district.
Quickly.
Yeah. What do you get pushing forward today that you don't get putting it off a week? It's not ministerial, Mark. Your staff report says that you have options today. You can postpone this for a week. So it's not the case that your hands have been tied. What do you get out of this, Harry and Serge, for rushing this forward and not letting the court play out? Right? You have to assume that everything you've been told here by the folks pushing this is going to play out exactly right. You had the sheriff trying to throw people out an hour before this meeting, and I'm guessing that most, if not all of you, didn't know that. That means that something else is going on here. What do you get other than potential problems that will be range from big to small for not postponing this for a week to let the lawyers see if they can't sort it out in a way that doesn't have a bunch of blowback and, God forbid, doesn't have somebody dead? What do you get out of it? That the voters have spoken? Go read Hernandez versus Town of Apple Valley. The voters spoke there overwhelmingly by a much bigger margin. The court threw out the results of that election because the election itself was illegal because procured by a Brown Act violation. You got a Brown Act violation, the judge has already spoken. So what do you get changing the status quo for a week? Ask yourself that, and make sure that you have that answer etched permanently in your mind, so that if, God forbid, we have to revisit this issue in a few weeks, you remember what you were thinking when you took the recommendation of your executive director to rush this thing through.
Holly, do you want to have any additional comments that we need to be advised of?
No, I think you have before you the choices, and this likely is going to end up before the courts no matter what, and so I just don't see any reason to delay for legal purposes.
Humanitarian.
Okay, call for a roll call. We have a motion and a second. Roll call.
Commissioner Blakesford is absent. Commissioner Desmond?
Yes.
Commissioner Jacob?
Aye.
Commissioner Kersey?
Aye.
Commissioner McKenzie?
Aye.
Commissioner Sprague?
Aye.
Commissioner Vanderlyn?
Aye.
Commissioner Wells?
Yes.
Commissioner Dedina?
Yes.
You have 8 in favor, 0 opposed, 1 absent. The motion passes.